I'm Shikha Dalmi of Reason Foundation, and thank you all for coming. Thanks to our two panelists, and big thanks to the Federalist Society that is live streaming the event and also is taping it for future viewing. Now, you all know why we are here. We are here to discuss the constitutionality and legality of DAPA. The Supreme Court held opening oral arguments on DAPA this week, and DAPA, as you know, refers to Deferred Action for Parents of American Citizens, which is Obama's executive order giving temporary relief, deportation relief, to about 4 million undocumented aliens. After reading the entire 100-page transcript of the oral argument yesterday, I think I have reached the Socratic state of unwisdom. Not only do I understand less, but I actually don't know what I don't understand.
I think that's Don Rumsfeld level of wisdom.
Yeah, thank you. Immigration law is a complicated and confusing mess that fewer people understand than the theory of relativity. And we have both of them here at this panel to unpack it all for you. Given how messy immigration law is, it is natural that DAPA has, heavily divided the country. And it'll be just absolutely shocking to all of you to know that libertarians are divided on it too. It has raised all kinds of issues of executive authority, separation of powers, and checks and balances. Those who defend DAPA argue that the president has broad prosecutorial authority to set enforcement priorities on immigration law, just as he does on criminal law, especially since the violations far overwhelm the resources available to prosecute them. And those who don't, they argue that such a systematic and mass relief without congressional authorization is tantamount to writing laws by executive fiat. Now, Reason has gone to very great lengths to arrange a very evenly matched debate, right down to getting two participants who were both born in Russia and immigrated to the United States and have nearly the same shoe size. They both have the same Russian first name and even the same first letter of the last name. Ilya Somin,
although in Russian, the letters are different.
Ilya Somin is a professor at George Mason Law School. Ilya Somin, a professor of George Mason Law School, will defend DAPA. You all know that Somin is a blogger extraordinaire at Washington Post's Volokh Conspiracy, but what you may not know about him is he's also a juggler extraordinaire. And he will do a concluding act of juggling the bobblehead dolls of all the 9 Supreme Court justices, including Scalia, at the end of this. So just stick around. The best will come at the end. His most recent book is Democracy and Political Ignorance: Why Smaller Government is Smarter. And Ilya Shapiro, to my right, is a senior fellow in constitutional studies at Cato Institute and editor-in-chief of the Cato Supreme Court Review. He co-authored an amicus brief on Cato's behalf against DAPA, against the administration. Now, the format that we have all agreed to is the following. They will both present 10-minute opening arguments and then get 5 minutes to rebut each other. I'll follow up by asking any unaddressed questions, and if they've covered all the ground, then we will just move on to Q&A by the audience, which will last, depending upon how much questions you have, about half an hour to 45 minutes. And just the one last rule is that wife and children are off limits. So you cannot show nude pictures or nasty pictures of your wives. We can all agree at the outset that both your wives are lovely and you both love your wives. So with that, I think Ilya Shapiro wanted to go first.
Sure. Well, thanks very much for having me. I'm glad that I've finally achieved such a level of cooldom that I can appear at a Reason event here in the grotto or the library, however y'all characterize this locale. I'm sorry I'm not sporting a black leather jacket, as I understand is the required haberdashery, but nevertheless, Look, I feel a certain burden because I clearly have more experience with immigration than Ilya Somin, having naturalized not just once, but twice, coming from Russia to Canada and then to the United States. But of course, like most immigrants, we both do a job that native-born Americans don't, and that's defending the Constitution. To have a little pre-buttal, because we sort of know what each of us is going to be arguing, Ilya Somin is going to spend some time talking about how Congress can't do anything in this area. It's kind of bizarre, even by libertarian standards, to my view. I kind of see immigration regulation, immigration law as an inherent power of any sovereign. I mean, we can talk about how, I don't think you need to go into kind of the penumbras and emanations of the migration clause or the foreign commerce clause or any of that, as how courts have sometimes justified it. I just simply see it as kind of bizarre to have a country without its parliament legislating about how to control its borders. And again, this is about the law. It's not about the policy. We can argue about, the libertarian open borders definition and how best to effectuate that. Also, I think Ilya Somin is going to liken this whole technical debate to simply prosecutorial discretion. And we don't have the resources in this area, like any other area, to enforce the law against every single violator. Take marijuana, for example. Ilya Somin's written eloquently about how neither the state nor the federal government go after college kids smoking up in their dorm room. That's true, but neither does the federal government say, all right, all of you who only violate marijuana laws in terms of personal possession and use, come register with us, and we'll give you a card that says for 2 or 3 years you are a lawful user possessor with attendant benefits, including immunity from consequences attending marijuana use, regarding gun use, regarding housing, federal housing eligibility, student loans, and attendant consequences. That is a key distinction, and why Texas and the other states are not challenging the first part of the president's memorandum, or the Secretary of Homeland Security's memorandum, that simply sets priorities on which illegal aliens to deport. Nobody is saying that you have to equally go after drug smugglers and human traffickers and violent criminals as the people who the only law they're violating is being in the country illegally. That's akin to saying you have to devote as many police resources to jaywalkers as to murderers. That's ludicrous, and no president, no administration has ever said that, has ever done that. Nobody is going to challenge that priority. Again, this challenge is about certain affirmative actions that go beyond simple prosecutorial discretion or a decision to prioritize certain crimes or certain violations above others. Also, Ilya Somin is going to talk about the unitary executive, and especially conservatives and perhaps right-leaning libertarians, I'm not sure, but certainly conservatives, Republicans, in the Bush administration at least, liked a strong unitary executive. Well, actually, a unitary executive doesn't have to be strong. The word unitary does not encapsulate the scope of executive power. It merely says that the president has to have control over everything that's going on in the executive branch. And so there's nothing inconsistent with saying that and saying the president's powers are narrow in this area or in any other area. So the kind of discussions of unitary executive are not really, don't answer the question either. And finally, what this really is about is government by blog post. This memo that is DAPA was published on the website of the Homeland Security Department. That's how we all learned about it. It's a kind of akin to some of the exemptions and waivers, suspensions of the law, another example of that in the Obamacare realm that tend to come out on Friday afternoons of a long weekend or something, so it's buried, but lo and behold, we're changing the law. And that's why, now to shift kind of more towards the affirmative side of my case, this title of today's event is a misnomer because it's not about preventing deportation, but about affirmative actions to provide certain legal rights, however tenuous or temporary they may be. And it's not about semantic arguments about is this legal status, Is it lawful presence? What do those means in normal English, in terms of legal terms of art? It's about how DAPA, how this memo, this guidance, this executive order created a circumstance where a class of people who before were not eligible for any sorts of benefits and rights are now granted, not simply know that they're not a priority for removal, but have other additional certain benefits and rights that can be removed tomorrow, absolutely, by the same president or by a new president. But be that as it may, however limited that right is, they do have something affirmative that they did not have yesterday, and that certainly the college kids smoking in their dorm rooms or the jaywalkers who aren't being prosecuted to the fullest extent as murderers do not have. I'm not going to touch on the standing issue. We actually agree that Texas and the other states have standing. By the way, Shinerbach, nice Texas beer. I'm also not going to talk about the Administrative Procedure Act issues. This DAPA was actually enjoined, stopped by the lower courts because the administration did not go through the procedural niceties of notice and comment rulemaking, as lawyers call it. When administrative agencies do something, they can't just do it arbitrarily. If they change new policies, they have to change substantive rules. They have to go through certain procedures. Those weren't followed. Ultimately, I think if John Roberts had his druthers and were writing this opinion, he would write an opinion based on that rather than even getting into the merits. But we know that's dry and dull and lawyerly, and you all want to hear some real fireworks. And look, at the end of the day, DAPA goes against the immigration laws, the INA, the Immigration and Naturalization Act, which establishes a 10-year bar from re-entering the country or pursuing any lawful status for anyone who's been in the country illegally for a year or more. It also has a very strict anti-anchor baby policy, however much this fear of anchor babies exists. Children cannot sponsor their parents until they're 21. You add in a 10-year bar for a one-year child, their parent's not going to be eligible at best for 30 years. And these are people who are benefiting from DAPA. And there's no provision at all in the existing laws for parents of lawful permanent resident, green card holders, and yet DAPA gives them those same rights. The previous experiences with deferred action, or with what the administration has used, what Ilya Somin also cites as past practice, are an apposite, because things, there have been a handful of times where certain discrete classes have been deferred, their deportations have been deferred, but those have been basically bridges between lawful statuses. That is, they were in the country legally as students, for example. Hurricane Katrina happened, washed out their school, they're out of status. But we provide the bridge, or the administration provided the bridge, until the times the school got stood up again and was running, at which point they had to be students again to be lawfully present. So a temporary bridge between lawful statuses. And in all of these cases that happened before, first there was an existing lawful presence to begin with, and then an imminent prospect of lawful residence in the future, either because this was clearly Congress was acquiescing, the wheels were in motion, or because the previous law contemplated these sorts of things and the agency was filling in sort of the interstices, the gaps that would otherwise make no sense. Here, that's not the case. I mean, hopefully, I do hope. If any of you have read my op-ed or my other writings, I agree with the Cato's line. Alex Naraste, there, our immigration analyst, I fully agree with the need to revamp our immigration system completely. It doesn't work for anyone except potentially lawyers and bureaucrats, but the president can't simply countermand those bad laws by his own. And don't take this from me, just from me. Take a much more prominent constitutional scholar who has said things like, for example, quote, America is a nation of laws, which means the president's obligated to enforce the law. With respect to the notion that he can just suspend deportations through executive order, that's not the case. There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system, that for the president to simply, through executive order, ignore those mandates would not conform with his appropriate role as president. Or, quote, if this was an issue that the president could do unilaterally, Obama would have done it a long time ago. The way our system works is Congress has to pass legislation. The president then gets an opportunity to sign it and implement it. These are but a few examples of the 22 times that this executive power expert has argued that DAPA wouldn't fly. And who is this person that felt the need to opine so many times? Barack Obama. Of course, after the 2014 election, he began singing a different tune and crowed 2 days after DAPA was enacted that I have changed the law. Not only did he do something that he admitted previously he couldn't do, but he admitted that he actually changed the law, which of course the president can't do. We have a history of rebelling against executives that think that they can suspend, rewrite, and otherwise waive the law. And that goes to my final point on the executive duty to take care that the laws be faithfully executed. This was a question probably added by Justice Scalia, did not get talked about at all at oral argument. But when the president is clearly acting in bad faith to bypass Congress, his powers are at their lowest ebb, as lawyers call it, from the canonical, most important foundational case on executive power, the 1952 steel seizure cases when Harry Truman tried to nationalize the steel plants because it was important to the Korean War. This shows you can read more in our brief. Cato's brief was focused on the take care clause, but I'll leave you with this from that opinion where Justice Jackson says, with all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of the court to be last, not first, to give them up. Without the law, there is nothing. And so much as I wished it would be possible for the president, any president, to simply rewrite this or any law in a way that would be more to my liking. We'll just have to wait for, I don't know, a President Cruz and a Nixon to China moment to agree with Congress to have that comprehensive immigration reform that this country sorely needs.
I'm sure Ilya Somin is dying to take this on, so good.
So I'd like to start by thanking the Reason Foundation and Shika for organizing what will likely be the first debate between two Ilyas on American soil. And of course, Ilya Shapiro for his thoughtful contribution, and all the rest of you for helping to make this subject great again, albeit in a way different than perhaps Donald Trump would want to do so. So I'm going to start off, as Ilya Shapiro predicted, with the fact that this exercise of power, these laws that President Obama has chosen not to enforce, are actually in many cases unconstitutional in the first place. Then we'll talk about how even if they are not unconstitutional, it is in fact perfectly permissible for the executive to choose not to enforce them with respect to certain categories of people. I'll also talk a little bit about the supposed affirmative benefits that may be granted by this action. And finally, if there's time, I'll touch a little bit on the take care clause. So first things first, does Congress even have a power to enact this law in the first place? I would say no, at least not if you care about the text or the original meaning of the Constitution. If you look at the congressional powers listed very carefully in Article 1 of the Constitution, the power to restrict migration just isn't there. There is the naturalization clause, gives Congress the power to grant citizenship to people, but citizenship is not the same thing as the right to migrate. Both at the time of the founding and today, there are many people in the U.S. who are not U.S. citizens, and there's a big difference between a power to grant citizenship and a power to restrict migration. Another place you could look for congressional power here is the Foreign Commerce Clause, which gives Congress the power to regulate commerce with foreign nations. However, both at the time of the founding and, by the way, for many, many decades thereafter, the dominant view of this clause was that it gave the power to regulate trade in commodities, possibly trade in services, but not the mere movement of people. The very same phrase in the Constitution also gives Congress the power to regulate interstate commerce, commerce between the different states, yet no one at the time thought that this meant that Congress had the power to forbid Americans from moving from one state to another. And what's true for interstate commerce is also true for foreign commerce. It's literally the exact same word in the Constitution that covers both. So the lack of an existing specific power that's listed for this actually led most people for decades to conclude Congress didn't have this authority, and in fact, Congress did not enact a general restriction on immigration for more than a century after the establishment of the US. It only enacted a few very minor restrictions on immigration that were focused perhaps on other powers of Congress. For example, the power to wage war and the like can be used to exclude foreign troops and spies and the like. But in 1882, Congress did enact the Chinese Exclusion Act, motivated by racist hatred of Chinese immigrants, and the Supreme Court upheld it on the kind of basis that Ilya Shapiro alludes to it, that it must be some sort of inherent power of any government. Well, if it's an inherent power, it can't be more inherent than the power to declare war or the power to have currency and the like. All of these powers are enumerated. So there's not some great power that the framers just thought, well, we don't even have to list this one. Rather, even the most important powers, the most fundamental ones, are actually listed. And if it was so inherently needed, then it seems very strange that the federal government got along for over a century without it. So the bottom line is, under the text and original meaning, this power simply isn't there. But let's assume for a moment that the inherent power theory is correct. Even so, President Obama's action is legal. As Ilya Shapiro alluded to, there are actually lots of areas of federal law where there's systematic non-enforcement of laws against particular categories of people. The example of the failure to enforce marijuana laws against millions of people who use them on college campuses and elsewhere is just one example. Far more people get away with violating the law as a result of this systematic non-enforcement than of anything that might happen in DAPA. The beneficiaries of this, in fact, include each of the last 3 presidents of the United States. Now, Ilya and some other people say, well, this is different because it's more systematic and explicit. You may even actually get a card saying you're one of these people where the law won't be enforced against you. But this systematic versus case-by-case distinction is actually a distinction without a difference. Unless case-by-case discretion is going to be completely arbitrary and baseless, it must rely on some sort of standards of the importance of the category of people, the severity of their violation of the law, and so forth. And if you can do this and take this into account on a case-by-case basis, you can certainly do so systematically. Indeed, the president, as the final power in the executive branch, the only way he can control his subordinates in a vast, sprawling modern state is to issue systematic instructions like this one. And this is, in fact, where the unitary executive comes in. It's not a matter of the scope of executive power, as Ilya suggests. It's a matter of whatever executive power exists has to be in the hands of the president, because that's who the executive power is given to under the text of the Constitution. And the only way he can exercise that power effectively in a vast, complex government is, in fact, to issue systematic instructions, which is what he has done here. He said, we're going to prioritize this group of people, this other group of people we're not going to prioritize, and so there's no misunderstanding about what can be done here. We're going to issue systematic, detailed instructions, maybe not the best and clearest possible instructions, but good enough instructions by the standards of government work, and certainly much better than simply implicit instructions or sort of backroom deals or whatnot. Now, perhaps the best argument for the other side in this debate is to say, well, this does more than not enforce. It gives some kind of affirmative benefits. But when you look at the affirmative benefits are actually claimed, it turns out that there's not much there. The one that's most often cited is employment authorization, but this is actually specifically authorized by the 1986 Immigration Reform Act, which specifically states that the employment of any aliens, quote, authorized to be employed by the Attorney General is permissible. Of course, in this case, the president has instructed the Attorney General to authorize it for this particular category of aliens. So this is specifically authorized by statute, doesn't require any specific or unusual new assertion of executive power. The statute is extremely clear. Now, lastly, there is the much discussed subject of so-called lawful presence. This sounds like a very ominous and important term. It's actually much ado about almost nothing. Lawful presence, as understood in disorder in immigration law generally, does not mean that your presence in the U.S. is actually legal. It does not mean that you're immune from deportation or anything else. It just simply means, for the most part, that you won't be deported until the president says, well, actually, maybe we will deport you after all. It doesn't legalize your status in the U.S. in any way. Moreover, presence in the U.S. is itself not actually unlawful. Only crossing the border can be unlawful. Strange but true quirk of immigration law. So there's really no actual such thing as unlawful presence under the existing immigration law, at least not unlawful in the lay sense of the term as opposed to the gobbledygook that we lawyers like to employ. Finally, if you are concerned about this lawful presence aspect, it would be very easy for the court to simply strike it down while leaving the rest of the order in place. Probably 98% or 99% of what the order does would be exactly the same if this particular provision wasn't in there. Lastly, if there is time, I can briefly talk about the take care clause, which, although briefed very skillfully by Ilya, Shapiro, and others, it's in the 100 page of the oral argument that was referred to by Shika. The Supreme Court justices didn't mention this even once, so they apparently don't actually care about the take care clause, at least if you go by the oral argument. But perhaps we should as constitutional scholars. We don't know for sure exactly what this clause means. It hasn't been litigated very much, but to the extent that it means anything, it certainly doesn't mean that the president has an obligation to enforce all laws at all times. No president has ever done that. It also doesn't mean that he can't take account of moral or policy considerations in deciding which laws to enforce. That also is done all the time. What it means, probably, according to historical evidence, is that he can't suspend the laws. He can't say that which was actually illegal is now actually legalized, but this order doesn't do that. It doesn't say you legally crossed the border when you did so illegally. It just says we're not going to go after you until we decide that we want to change our mind and that we will. So it doesn't actually suspend any laws, merely chooses not to enforce them. Finally, there is this, and this is what I think this debate is centrally about. Under our system of government, we have a 3-level protection for individual liberty. Before your liberty can be violated, the legislature has to pass a law. Courts have to choose not to strike it down as unconstitutional. And finally, the executive has to choose to enforce it. That's a kind of last line of defense. If the other side in this case wins, that last line of defense for liberty will be, at least in many situations, significantly undermined. And there's no need to do that, whether you're a libertarian and you care about liberty for its own sake, or you simply care about maintaining the constitutional structure of separation of powers and divided government. There's no good reason to strike down this order. To the contrary, it goes against the Constitution and against the fundamental principles of our government. It would violate all of that to do that. So I very much look forward to the rest of the discussion. Thank you.
What you've seen here is, I think, emblematic of the difference between our native or birth cities. Ilya Somin is from St. Petersburg, with this very romantic view, kind of pie in the sky, very pretty picture of how all this works and the brotherhood of mankind. We should just hold hands and sing Kumbaya and move wherever we want. Whereas I, from Moscow, am hard-nosed about national power and understand that there are legal and authority-based restrictions on what can be achieved in this or the next world. And so, for example, Ilya's point about the lack of existing or enumerated government power, this isn't the only area where I would say that the Constitution levies inherent authority on Congress. Another one would be eminent domain, an area that is very familiar to Professor Somin, obviously, and yet there are allusions to it, but nowhere does it say that Congress shall have the power, or the executive shall have or the government shall have the power of executive eminent domain. It's just presumed that sometimes the government needs to take land for public goods. The systematic versus case-by-case point, that goes to the Administrative Procedure Act. If you're putting in some sort of systematic, significant change, that needs to be based on notice and comment. It kind of goes atmospherically towards prosecutorial discretion, I suppose, but mostly it resounds in the law on the APA point. And so I don't push this fact that, this really is, it shows that it's a new policy that's being put in place, which again means that there needs to be notice and comment. The benefits statute that Ilya mentioned is not controversial. It's the trigger of those benefits that's at issue, and that's what DAPA represents. It's not that DAPA created these new benefits or shaped them for the newly eligible people. It's that this trigger is something that goes against congressional policy. The lawful presence, legally present bit, look, this makes no sense to anyone. This came up during oral argument. At one point, Justice Alito said, Solicitor General, are you saying that lawfully present does not mean legally present? And he said, yes. Like, I don't understand. What does this mean in terms of the English language? Don't give me the term of law. I mean, but again, this is not a debate about semantics. It's about whatever is being created here: status, presence. How call it a rutabaga. This a bundle of sticks is new, and that's what's not authorized. And finally, the take care clause. Look, that question, I think, was added to have a comprehensive briefing on everything that's possibly relevant. It was always the constitutional issue going to be tied into the statutory one. And I think kind of inherently, if the president is violating the law here, he's violating his constitutional duty. And so rather than, in conclusion, looking at the pretty Potemkin village that Ilya Somin is throwing up here, we need to be in the real world where there have to be real limits on executive power, even in areas where Congress has fallen down on the job.
So I'd like to start off my little rebuttal with the most important issue raised by Ilya Shapiro, which is the long-standing conflict between Moscow and St. Petersburg. There is a real reason why, when the communists took power in Russia, they moved the capital to Moscow. Among other reasons, it's because St. Petersburg is a traditional center of those Russians who, like myself, want to see liberal democracy, individual freedom, and justice established, whereas Moscow is a traditional center of Russian nationalists, and of communists and other kinds of oppressors. So if you want to see what is truly realistic and what fits the modern world best, it is the face of Russia that emanates from St. Petersburg and not the one that emanates from Moscow. And I think this is actually a little bit relevant to the other points we raised in a debate, in that I want to see a free society where government is limited by strict separation of powers and where we have strong presumptions in favor of liberty. That's not the tradition of Russian government, sadly, even in St. Petersburg, but it is the structure of our government, despite obviously some deviations and flaws. So first things first, Ilya Shapiro is correct that the Supreme Court has imputed some other powers as supposedly inherent, including the power of eminent domain. But for the first 100 years of American history, as with immigration, so with eminent domain, the Supreme Court, and by the way, almost everybody else, assumed that the federal government had no power of eminent domain. When the federal government wanted to take property in the states, it asked the states to do it for it, and if they said no, the federal government was out of luck. In 1875, the Supreme Court made a very misguided decision going the other way on this. Actually, only a few years before, they also screwed up on the immigration context. So basically, to make a long story short, in the 1870s and 80s, the Supreme Court, in a number of egregious ways, departed from the original meaning of the Constitution.
Don't forget the slaughterhouse cases.
Yes, the slaughterhouse case is another example of this. So if you are just a believer in the living Constitution or in just strict adherence to precedent, no matter whether it's a stupid president or not, then that's fine with you. If you're an originalist, as I think Ilya Shapiro is.
A stupid precedent or president?
Both, perhaps, but in this case, precedent. So I think, therefore, that the original meaning of the Constitution, the text, is very much on my side here, both with respect to eminent domain, about which I've written a book, and also with respect to immigration. Now, the issue of these affirmative benefits, as I've said before, the most important one, employment authorization, is specifically authorized by statute. Congress actually gave this authority to the president, and he can trigger it anytime he wants, simply by issuing an order to the Attorney General. On the lawful presence here, I share Justice Alito's and Ilya's dismay about the terminological confusion here. All I can say is what I said before. This is an area where the legal gobbledygook uses terminology that is different from what ordinary people use in the rest of their lives, but it is in fact the case that lawful presence does not mean legal presence in the ordinary sense of the word, and perhaps even more importantly, there's not actually such a thing as unlawful presence. There's only illegal crossing of the border, and nothing the president's order does makes crossing the border legal in a situation where it would otherwise be illegal. But finally, if you don't like the unlawful presence part of it, you think it's illegal, it would be very easy for the court to strike it while leaving everything or virtually everything that's actually important in this order completely in place. So much more could be said about the take care clause and other things, and especially about St. Petersburg versus Moscow, but I will for the moment leave off and look forward to your questions. Thank you.
Thank you, both of you. As we had agreed, so I have a couple of questions of my own. Ilya, Somin, I will start off with you. I mean, you lay out very compellingly how the president has wide prosecutorial discretion to do what he is doing. But what I haven't heard from you is, and I think this is what troubles a lot of people, is what are the outside limits of this prosecutorial discretion? Are there any? He has decided to give deferred deportation or lawful present status to 4 million people. Can he give it to all 11 million people? Can he simply stop removing people from the country, which will be essentially declaring open borders, which will not bother many of us over here, but it is a legitimate political issue. So could you say something about what are the limiting principles to this prosecutorial discretion?
Yes, I think there are two plausible theories of this, both of which come down on my side. One, the sort of more moderate one, says you can have broad discretion in how to, in which categories of people to enforce the law against, but you can't engage in what legal scholars call complete abdication. That is, not enforcing that law against anybody. Obviously, this order falls well short of that. It frees temporarily at least the 4 million people, but not the other 7 or 8 million that, according to estimates, are in the country legally and are covered by these laws, so it falls well short of abdication. I would actually go further than this and say that, textually speaking, the power of enforcement is completely within the executive branch. That is actually traditionally the way that it was viewed. The word executive actually comes from executing the law, so I think it would be within the president's power to even say, I'm not going to enforce this law against anybody. I believe it's better and more important to prioritize other laws that we can enforce categorically over this one. And you might say, well, that would be terrible, but of course, there are political constraints on this. And sadly, in the modern state, where government is vastly overgrown and we can prosecute or go after only a very small percentage of all of the lawbreakers out there, some 70% or more of Americans have violated just federal criminal law, not to mention civil law, and this law here is actually civil and not criminal. So the main constraint on executive discretion is political. I'm not satisfied with that. I would like to get rid of many of the laws on the books. I would like to more rigorously enforce the limits on the scope of congressional power, including power over immigration. If we do that, then presidential discretion will shrink because of the fact that in that situation, most of the laws remaining on the books will be ones where there is a very broad political consensus that they should be federal laws and should be rigorously enforced. But until we get into that world, we have to live with the fact that there's pretty broad executive discretion here. And by the way, even under his position, there will be considerable executive discretion too. Essentially, if I understand Ilya correctly, the president could implicitly instruct his subordinates not to go after these categories of people. The mistake he made is issuing a more systematic executive order and giving people cards to that effect, but he could do probably 80 or 90% of the same stuff just sort of implicitly and behind the scenes. So it seems to me a lot of executive discretion here is going to be inevitable, and the remedy for that, if there is one, is to cut back on an amount of federal laws.
So your position is that the only limits are political limits, and there aren't any internal statutory limits, and we've already, you've already said
that is my
there aren't
position,
any.
but a more moderate version, the abdication theory, also cuts in my favor.
But the abdication theory, I mean, if he deports one person, theoretically the abdication theory is satisfied, right?
Maybe advocates of this theory have not really explained exactly at what point abdication happens. It could be at the point of zero. It could be at the point where just the overwhelming majority are let go. But on any reasonable interpretation, letting go far less than half of the people who are covered by this is not abdication. If it is, then we've also abdicated on the marijuana laws and quite a lot of other federal laws.
Let's just be clear. This is not a case of abdication or suspension of the law, as the technical, philosophical, or political theoretic term is. This is a case of dispensation. The argument is not that the president, unlike in Obamacare, is making waivers and suspending the laws to certain classes. He is affirmatively rewriting the law to provide new sorts of benefits, rights, etc. That's the argument, and that sort of dispensary power. There's a long history. Again, there are a few briefs that go into how this compares to the Stuart kings in the 17th century.
What benefits do come? I mean, Ilya mentioned work authorization, and the big issue determining the standing of Texas in suing is driver's licenses. And driver's licenses, I mean, according to Texas, which it subsidizes, will impose a huge burden on Texas. But that's not a federal provision. That's not a federal law which is telling Texas it has to provide driver's licenses to these people. That's its own law. So it can either get rid of that law, or it can stop subsidizing anybody's licenses, which would be the libertarian outcome, right? Why should Texas not be asked to do that? And I mean, and this is another issue that came up in the court yesterday, which is that if Texas is going to claim injury simply because it has to bear the cost of a federal law, then the question for you is, what is the limiting principle for states that want to sue the federal government? Then it's open season on the federal government, which also won't be a bad outcome from a libertarian, right?
So this goes towards standing, and I've tried to fight, especially in a lay, non-legal audience. Typically when I'm not speaking to an all-legal audience, that means I don't have to, dumb down the presentation as much, right? But on standing, look, I commend to you the brief of Ernie Young and certain other scholars of a federal jurisdiction that goes into all of these things about, a self-created injury because of this law, and they don't have to subsidize. This came up during oral argument. If they stop subsidizing just for this class, how they determine who that is, because they refer to the government and to the federal government about who is eligible to be in the country legally, and that's how they determine who's eligible for licenses. So they have to keep a separate database. It's not even clear whether it's possible. And then they would be sued by the federal government for differentiating between different immigration classes that the federal government has considered to be, lawfully present, or however you want to call it. So it's not even clear that there's a legal, practical solution to be able to do that. But I want to answer your first question, which is, I think, more certainly interesting, at least to a non-legal audience that goes away from the standing issue, about what benefits attach, because the license is a state benefit. There are other state benefits as well, which is how you establish more standing. So work authorization, Social Security eligibility, earned income tax credits. There's a host of, once you get the sort of status that, again, I don't want to get into semantic games of whatever it is, but for the time that DAPA is in existence, that the president hasn't changed his mind and reversed it, there is eligibility for, by statute, triggered by considering you to be in this category of deferred action officially, these various types of significant benefits. Work authorization and being able to be here legally is certainly are certainly the most important ones, but they're not certainly the only ones that impose costs or the only legally significant ones.
Now, work authorization isn't the whole. I mean, first of all, to call that a benefit, in my view, from a libertarian standpoint, doesn't sound right.
I'm not arguing philosophy. I'm a simple constitutional lawyer.
I understand that, but the whole point of a work benefit is to actually prevent undocumented people from going on welfare, right? So that they can stay in the country and earn a living.
Undocumented people aren't eligible for welfare. This is not, the welfare argument is a misnomer about immigration reform efforts generally.
So which benefit are you worried about that will actually impose a cost on taxpayers? I mean, that's
Wait, you're getting me back to standing now?
No, I'm just asking you.
Because your original question was about kind of a more interesting substantive one that was going towards, what exactly, how is this different from prosecutorial discretion? But now you're getting back into the standing issue of imposing costs on taxpayers. That goes to more to standing.
Okay, well, answer the standing issue. I don't know.
That's, the standing is about the states. There are 26 states, and beyond driver's licenses, there are a host of state programs that give various benefits to people who are in their state legally, whether it's sometimes state welfare. In certain states, that does trigger state welfare rights as well. Eligibility for student loans. There all sorts of state programs exist that benefit, that once you pull the trigger, that DAPA does, makes this class of aliens eligible for.
I wonder if I can perhaps in the spirit of charging in like a fool where wise men fear to tread, perhaps I can clarify a little bit the standing question, which we do largely agree on. Essentially, what standing is the doctrine which says you're not allowed to file a lawsuit unless you've suffered some sort of tangible harm of some kind. And here, Texas is saying, well, the harm is that we have a policy of
My
giving...
harm is I'm out of beer.
Yeah.
Could somebody please sacrifice themselves and get me another one,
Now
please?
that is a really severe harm, but Texas is minor by comparison. But what they're saying is that the situation is that under their law, Texas's law, they have a practice of giving driver's license to anybody who has lawful presence in the U.S., and now they'll have to give out more driver's license, which costs money to print them and file the applications and do other bureaucratic rigmarole. And so that's the harm they say they're suffering. Other people say, well, they could just change their laws, or they could enforce their existing regulations more strictly. And I think they could do that, but obviously that imposes a cost on them as well. So I think they're right to say that they have standing under the current precedent. And moreover, I think the current precedent, to my mind, is actually overly restrictive. It's not based on anything in the text of the Constitution. To my mind, there should be open season on the federal government. Not that every lawsuit should succeed, but that very few lawsuits should be kept out simply on the basis that you haven't suffered some kind of tangible harm, which is nowhere listed in the Constitution. Rather, we have a way of getting rid of frivolous lawsuits at the very early stage of the proceeding. I can talk to you about the exact legal technicalities here, but the short answer is that using those is not more difficult for the courts than getting rid of cases on standing. In fact, the standing analysis often is more difficult. However, the practical issue here, for those who are worried, well, maybe if this goes forward, state governments will end up paying much more in welfare to people. Empirical data does not support that. In fact, having more immigrants, including more undocumented immigrants, does not overall increase state welfare spending on net. Alex Noverstek, who's in the audience here, has a good paper on this from Ilya Shapiro's organization, the Cato Institute. So while there's an important legal issue here that I have tried to explicate as best I may, the practical issue for those who don't care about the legal issue here, there is not actually a significant practical issue.
So let me ask you one other question, and then we'll open it to the audience. So, you know, the statutory language, I think it's in the INA, the Secretary of Homeland Security has authority to offer parole for urgent humanitarian reason or significant public benefit. Now, you know, I don't understand why that does not actually go in the favor of the president over here. Why is keeping American children with their parents not construed as a significant public benefit, even by, you know, the most right-wing congressmen? I mean, until very recently, till we had the whole Trump phenomenon, family reunification was a core aspect of immigration law. So isn't it in some way furthering the major goals of immigration law to have this?
Family unity always has been certainly a strong consideration here. To the extent there is any sense to our immigration laws, of which there is very little, they're often contradictory. That is perhaps one animating feature. But we have to look at what the law clearly says. And there are very strong punishments against explicit statutory punishments, like the 10-year statutory bar that I mentioned, like the 21-year anti-anchor baby provision that I mentioned. And so these sorts of the extraordinary family hardship language that you mentioned certainly has been used sparingly in individual cases, but to read it as providing the authority to solve the entire case in the first place would read out other much more explicit provisions of the law. I mean, I wish it were otherwise, but this is it's just that does not give carte blanche to say, okay, the Secretary of Homeland Security finds that family unity is so important, and therefore anyone with a U.S. citizen child automatically gets status, overriding the 10-year bar, the 21-year provision, all of that sort of thing. So, you know, it's the way it's been used in the past is indeed for like a 96-year-old Filipino grandmother who otherwise, would have to be deported, and that makes no sense and is not a burden on the public fisc or anything like that. Kind of individualized cases. Certainly, it's never been used in large, non-discrete classes.
Can I just comment on it very briefly?
And then we'll open it up.
So I agree with Ilya Shapiro that it doesn't necessarily cover all of the people who are covered by disorder. However, it's a little bit too quick to say that if you apply this broadly, we would read out all these other provisions, because all these other provisions can be perfectly plausibly read as in force unless and until the Secretary of Homeland Security creates this parole exception. There are many, many provisions in the law which say law X applies unless some official decides that he's going to exempt people or parole people. Like, it's actually a pretty standard legal tool. As I said, I'm not certain this is enough to cover all 4 million people. It might not be, because there are many different people with somewhat different situations. Also, the language of this is somewhat vague. What's really urgent? What's a public benefit? Lawyers can argue all day about exactly what that means. But I do think this does go away to at least covering a good many of those people.
Yeah.
Professor Somin, you said that you didn't buy that the right to restrict immigration could be inherent. Does that mean you say there are no inherent powers not written in the Constitution? I mean, does Congress not have the power to root out foreign agents living in the United States? I mean, was the Louisiana Purchase unconstitutional?
So my answer is that the way the Constitution is written, it is a system of enumerated powers. That is, powers that are not granted to the federal government, that are not enumerated in some way, are not there. You mentioned foreign agents. If there actually is an enumerated power, and that is called the power to declare war, also the power to make laws to provide for the common defense and the like. Obviously, defense against foreign agents is a pretty obviously falls within that. On the Louisiana Purchase, this is a more complex debate, and Thomas Jefferson, the man who made the Louisiana Purchase, the president who did it, he actually thought it was unconstitutional. I actually agree with his Secretary of the Treasury, Albert Gallatin, who argued that it's authorized by a combination of the treaty power and also the power to provide for the governance of federally owned territories under Article 7 of the Constitution. So Article 7 envisions an authority to have territories which are not states. And the treaty power, to my mind, is a power to make treaties on any subject which are otherwise within the scope of federal power, and that includes governance and acquisition of territory.
If the power to declare war and gives the power to root out foreign agents, why not stop mass swaths of immigration?
Because most of those people are not foreign agents in the sense of spies and the like. Just as the power to root out domestic American citizens who might be foreign agents is not a power to go after any Americans the federal government might want to on the excuse that maybe they might be foreign agents in some ways. So the same point applies to this immigration authority.
Did you want to respond to that? Jared.
So Ilya Shapiro argues that if we allow this to go forward, then our country's over, because now the executive can do whatever it wants and there's no separation of powers anymore. But then Ilya Somin argues that if we don't allow this to go forward, then there's no separation of powers and we're in dystopia. And
much less.
Okay, there's much less. So I want each of you to pick an example that shows that the other one is completely exaggerating and making this up. Because both things kind of show.
So the question is, just so we should have repeated the first one as well, which is about where is the inherent power to police foreign agents and the Louisiana Purchase. This question is about that I argued that if my position loses, then there's no limit on executive power, and we lose the country because the executive can do whatever it wants over policing the border and regulating immigration. And conversely, if Ilya Somin says that if his position loses, then that violates the separation of powers as well, because Congress doesn't have the authority in the first place. So he wants us to, the questioner wants us to give an example of what again?
Kind of showing that the other person's exaggerating.
Showing that the other person is exaggerating.
So.
Well, look, I think Ilya Somin is exaggerating because this is simply about Congress's power to regulate immigration. I would like Congress in general to reassert its powers more broadly in various ways, not to expand federal power, but to take back power from the executive branch, from the administrative agencies and the White House in various ways, and this is just one more area of that.
Yeah. So I think if he's exaggerating some things, it's in the sense that he's saying that there will be this big new executive power that's granted here. At most, the most the executive would get is the power to do systematically what he already does, and unavoidably does, by the way, sort of implicitly and behind the scenes, which is to pick and choose.
Systematic is not the opposite of implicit.
It doesn't matter. You understand what I'm saying. We thought that we were going to get away with from talking about legal gobbledygook. So basically, the point here is that when you have a situation where over 70% of Americans have violated federal criminal law, even more have violated civil law, we can only catch a very small percentage of lawbreakers. The president must make choices. That gives him a lot of discretion that can easily be abused. But the way to fight that is not with lawsuits like this one, but to cut back the scope of federal power. And a really great place to start is a place where federal power was not actually authorized in the first place, which is this supposed general congressional power over immigration.
I'd be okay with cutting back federal power generally, but this debate is about the balance of that power, whatever its scope.
Okay, I would only add to that the president choosing not to enforce laws that the Constitution didn't authorize in the first place in no way undermines the separation of powers. In fact, it furthers it.
Well, if the laws don't exist in the first place and the president is inventing new laws then rather than not enforcing them.
You guys can take it outside later. Yeah, David.
Would it change either of your position if President Trump comes in and he uses this database of DAPA to round up all the people in the country and deport them? It seems like what a perfect enforcement tool. You now have the list of all the people, the majority of the people who are here illegally. What a perfect enforcement tool. So does that change either of your position if it does turn out to be the best enforcement tool ever?
Yeah, it doesn't change my legal position, no, but it is a risk of this policy. But by the way, it underscores the way in which this policy is not actually immunizing anybody from deportation or changing the law. If it really did immunize them, then Trump couldn't do that. So I agree that it would be better for the executive and Congress and everybody to recognize simply that there is no power to bar the vast majority of these people in the first place, and then that would make the rest of these considerations mostly irrelevant. And the alternative would be better if Congress were to pass a law explicitly stating all these people are here legally, they have the right to employment and so forth. So those things would be a better world than the one we actually have, but through the fault of both President Obama and the Republican Congress, we weren't able to reach agreement on this legislation, and through the fault of the Supreme Court and various other people as well, Congress has been allowed to take power in this area and in others like eminent domain that doesn't really belong to it. So at the very least, we should have our last line of defense for liberty here, which is the executive discretion not to enforce certain laws or laws against certain categories of people.
Actually, that raises another question that I had, which was that under your
Can I
theory,
answer that?
if yeah, go ahead.
The question, by the way, was would it change our positions if President Trump used the DAPA database to round up the people that had registered to deport them? First of all, if President Trump even happens, I want to know the coordinates to Galt's Gulch. The Kochs have not informed me yet. I don't know if you all at Reason, if you find out, let me know. I'm very interested. But no, that's perhaps a reason why people eligible for DAPA might not even sign up, because they might think it's a trick or in the future could be used down the line negatively once they're in the system as affirmatively admitting that they are in the country illegally. On the eminent domain point, I would like to read a very obscure provision here. It's Amendment 5 of the Constitution. Nor shall private property be taken for public use without just compensation. If there is no inherent power, federal power, because this is before the Bill of Rights applied to the states, if there's no federal power of eminent domain, then I guess the takings clause is a redundancy.
Not true. There was these things called federal territories, which were not states. And in those areas, the federal government had and still has all of the powers that in the states belong to state government. So nobody doubted that the federal government had the power of eminent domain in the territories and in the District of Columbia, just didn't have them in the states because Article 7 of the Constitution gives Congress the power to make rules for the governance of territories. So the Takings Clause is not
So
redundant.
the power of eminent domain is inherent, but only in Article 7 with respect to territories.
It's not inherent, it's specifically listed.
Again, like I said, I'm going to give you both one round each. After that, you take it out, okay? So we need to cover as many questions as we can. And
I
I'll say-
apologize, I'm sorry. I will not try to seize
I don't
inherent power.
apologize.
Yes, sir.
So my question was about the foreign commerce power. One of the first commerce cases dealt with steam engines going back and forth, and the Supreme Court said that commerce extended to vessels exclusively employed in transporting passengers. So do you recognize the power of commerce over those channels of commerce that potentially Congress could exclude people from being able to use?
Yes and no. Yes, in the sense that they could regulate. Okay, so I thought the question was already understandable, but
for the audience, for the viewing audience.
I think they can hear it, but go ahead.
Can they hear it? Oh,
so the question is, couldn't Congress
try to help you all out there in cyberspace.
Okay. So for the benefit of the denizens of cyberspace, the question here is, what about Congress's power under the Foreign Commerce Clause to regulate the channels of commerce, such as steamships or other ships and the like, and couldn't Congress just simply say we're not allowed to come in here on a ship using that power? And I think the answer is twofold. One is, as the Supreme Court has long recognized, in cases going back to the early 19th century, Congress cannot use its enumerated powers in a pretextual way to regulate other things. So they can do things like regulate the steamships or any ships for safety or for harm that might be caused by their travel back and forth. But what they cannot do, at least under the original meaning, is use that as leverage to regulate other things. Otherwise, they could use the commerce power, or really their other powers as well, to leverage pretty much anything. For instance, they could use the interstate commerce power to say, well, you can't transport people or goods from any states that have laws we don't like, say that don't have the death penalty, or in the days before the 14th Amendment that don't have slavery or whatnot. And that kind of leveraging was considered impermissible, and it would be impermissible with respect to immigration as well. And it was so argued actually in the 1790s by people like Jefferson and Madison in criticizing the Alien and Sedition Acts. This is not an argument that's new to me. So it's true, the exact boundaries of this, there is some fuzziness, but this is clearly on one side of the line. If you say, well, we're going to use our power to regulate steamships in such a way as to assert a broad power to prevent anybody from coming in whatsoever, that's clearly a case of leveraging and pretext. I would add also that when it comes to the Mexican border, which is a lot of what this is about, we're talking about people crossing on foot and the like, and not using established channels of commerce in the same sense. So it still might, even that argument might not fully apply to those cases.
Okay, yes, sir.
Does the Supreme Court in this case have the option of upholding the deferred action portion of the order while enjoining any of the triggering of the benefits, perhaps on the theory that the deferred action was taken in good faith given the limited resources the government has, while the triggering of the benefits was not taken in good faith and therefore violates the take care clause?
I think so, yes, that this order has several different provisions, and it's perfectly possible for the court to say some of them are legal and other ones are not. When you look at laws enacted by Congress, there are sometimes presumptions against severing parts. There's a very complicated set of legal doctrine that says when you can strike down one part of a law and leave the rest in place and when you can't. But with an executive order, the risk here is much smaller in that with Congress, if you sort of make a hash of one of their laws by striking down one part that sort of makes nonsense of the rest, then it might be complicated and difficult for Congress to go back and fix it. Here, if the executive doesn't like the result, he can fix it at the stroke of his pen, so those concerns are much smaller. And as I've indicated before, the single most potentially vulnerable part of this lawful presence is actually relatively insignificant part of it. So even under the principles that the court normally applies to the severing of provisions from laws passed by Congress, I think even under those principles, this would be okay.
But then won't that the person who can stay here as a lawful presence but not work, when they work, then they can be deported or
They
some
can,
other
they can be
action?
deported anyway. Because legally speaking, as the president himself has repeatedly said, legally speaking, this doesn't make their presence in the country lawful. All it does is exempt them from executive discretion on it. Lawful presence, I've tried to explain, has nothing to do with whether you're actually in the country legally or whether you entered legally.
It's Schrodinger's legal status. You're lawfully present but not legally present.
Yeah. Blame the gobbledygook nature of legal terminology, but this is one of those areas where legal language is different from sort of ordinary common sense language. I wish it wasn't, but it is.
So let's have maybe one, maybe two more questions. One more question. Who wants to do the concluding honors here? Well, yeah, go ahead.
This is particularly for Ilya Shapiro. Is there a version of this kind of formal declaration from the executive branch of what kind of discretion they will use in enforcing immigration law? Is there a version of the kind of initiative that they took here that would meet your concerns on the constitutionality of that? Is there a kind of pared back or more minimalist version of this kind of executive authority exercise that would satisfy your concerns while still having the same basic effect of more explicitly, systematically saying this is a particular category of persons that we are going to use our prosecutorial discretion to avoid going after?
So the question is there a way that I could rewrite DAPA to make it legal or constitutional or not violate the take care clause? And my answer to that is, if it were simply a memo, if it were simply this first part of DAPA saying, these are the tiers of priority that we'll go after, and we will not go after you if the only law you violated is illegal entry. I think it's somewhat foolish to do that. It's akin to the police putting out a memo saying, because of resources for the next couple of weeks, we will be deprioritizing simple theft and burglary in favor of violent crimes to persons. That's kind of like a get out of jail free card to petty thieves, etc. So that second part of DAPA, which acts as that trigger, as we've been calling it in this debate, I don't think there's a way to rewrite that. But if you want to memorialize your priority guidance, sure, go ahead. Nobody is challenging that. But I don't think there's a way of rewriting the part of the DHS memorandum that is being challenged in a way to satisfy my view of the immigration laws or constitutional duty to take care.
Did you want to respond?
Yeah, just briefly, I think that first part, which he concedes is permissible, is in fact the most important part. And it's true, if you did it with burglary and petty theft, it might be a bad thing. They're still legal, but free movement of people who just want jobs and opportunity, that's not a bad thing. And it's a good thing for the executive to systematically deprioritize it.
Absolutely a good thing. Doesn't make it legal.
I think you just said that it does. But I would say that unlike Ilya Shapiro, Texas and the states actually claim that they are challenging this whole thing, and at least their official legal position, at least prior to oral argument, is it must all stand or fall together.
Well, thank you very much for coming, and please join me in thanking the two guests for a very, very good debate.